So hi, everybody. My name is Mark Potkowitz. I'm an attorney and director of the Legal Innovation Center at Ulster University in Belfast, Northern Ireland. And on occasion, I'm an adjunct professor of clinical law at Brooklyn Law School. And now I'm seeing a big picture of myself on the screen, which is a little bit distracting, but it's good. I will notice if I'm gesturing too much and becoming distracting. So the purpose of this talk and this lab is to talk around issues of privacy and surveillance. And I think in order for us to understand what privacy is, it's sort of important for us to get a better sense of the legal foundations that we have bringing us to what this notion of privacy means. Because privacy is a relatively new term. It is something that has exploded in the past 10 to 15 years, maybe 20. People are much more concerned about their privacy now than they were 30 years ago. But 150 years ago, people weren't as concerned about privacy as they were 100 years ago. And it seems the more we progress, the more people get concerned with their privacy. I'm just turning off my secondary display to see if I can reduce the glare on my glasses, and it seems to have worked. So as we're getting into this, I know that there are some people here, and I would encourage those of you who are comfortable to come off mute. And when I say privacy, if you could say a few things about what privacy means to you, I think it could help shape the conversation. So if you're not comfortable coming on microphone or coming on camera, if you want to type in the chat, I can read aloud what it is that you've written, because I think that this could be incredibly dull if all you hear is me talking for the next interval about what I think privacy means, because I have some very specific views on privacy that might not be the normative views.
I think it's an interesting question, Mark, because my mind sort of jumps everywhere. The first thing that comes to mind is just the association with data and privacy, you know, like the GDPR. I'm living in Europe, and that's, you know, so privacy for me is the right, or I guess the right to withhold information from people outside of yourself.
To be able to control your personal information, right? Like you want that control. Like you're fine to, right? If you're going to share something, you want to be able to give consent to that sharing, right? You don't want anyone to just be able to come in and take what's yours, right? This is your information.
So, I mean, when we talk about privacy, we start to say that there's some pronouns that we're using. You know, my information, there's a sort of personal sense of ownership over information or data like it's property. And the idea is to have some sense of control over what sort of information about you is made public. And that's sort of another interesting component that's emerging here, is that we seem to think that notions of having things publicly shared seem to violate this right of privacy. We can talk about rights in a few minutes too, which is another interesting topic about what comprise rights, and which rights are positive rights, meaning that they must be supplied to you, and which are negative rights, meaning that people can't interfere with those rights. So when you think about privacy, we seem to have this idea of, again, ownership over some information about us, some proprietary rights, some property rights, perhaps in data or information, which we can just use synonymously at this stage, and the idea of controlling it somehow around us. From whom, is there anyone specifically from whom we're concerned about having this data available? If I can sorry, I kind of stumbled over the phrasing of that. From whom are we trying to keep this data private? Who is it that is on our list of people we do not want to see this information? In broad strokes.
Sorry, I was going to say, I guess it depends on what information we're talking about. So I know we're specifically talking about data right now, right? But like in general, when you want something to be private, that could be from anyone. That could be from your closest friends to the government. It could be, and everyone in between. When you're talking about data privacy, a lot of people tend to talk about it in the context of people who might be able to profit off of this and the government, right? So then you're worried about the government and then big companies, because people get a hold of your information, and then, for example, they can sell it, they can use it for, you know, things that you never even told them they could, or you didn't even know were happening behind the scenes. That happens all the time. So I think that is what most people are worried about, or probably want to keep their information from.
And Samir, you as well had some ideas?
Yeah, just as a general point, I mean, I think we want to withhold information from people or entities that might have the we want to prevent them from being able to use our data in malicious ways. And that can be in many different ways, right? It could be a secret that I withhold from my friend because I don't want to, well, I don't want them to perceive me in a negative light. So just to, prevent other people from being able to do harm to us.
Well, sure. And I think that the notion of from whom we want to protect information shifts over our lives. Certainly when I was a teenager, there were things I didn't want my parents finding out, sneaking in after curfew or claiming to have been somewhere that was on the approved list and going somewhere that was not on the approved list. I was less concerned when I was 15 years old about privacy from government than I was about privacy from my parents. So there seems to be this consensus that we're emerging that we have this notion of our personal, some kind of property interest in information, whether it's data, whether it's our preferences, whether it's where we have been geographically, whether it's our ideas, and a notion of controlling who can access this information. We tend to think that there are certain things about us that we might not necessarily be as concerned with if we don't think there's a negative way that it can be used against us. So the fact that I'm wearing a maroon sweater right now is something that I don't know that needs to be private for any reason, unless I live in a jurisdiction where for some reason maroon sweaters are banned, in which case I can get in trouble. But this notion of privacy that we kind of mentioned around a few times, I think I should probably get into some of the historical background on what privacy is, because I think that it can help inform the conversation we have now. And as I'm doing this, feel free to jump in and ask questions, but also think about what has changed in the past 30 years, maybe, or 15 years, or 10 or 5, that might affect how you perceive privacy. And think about what your notions of privacy are now versus what they were 5, 10, or 15, or 20 years ago, or however long back you'd like to think about it. So one of the things that I was talking about before we began was this notion of legal philosophy. And I know there are some philosophy people in the room, so I encourage you to jump in and speak about this. But what I will kind of say is that the talk that I'm about to give right now on philosophy and jurisprudence is one where I've truncated a lot of it for the purposes of this forum. It doesn't make sense for me to do an exhaustive lecture on jurisprudence. That's not why people are here. But I will say that it is important, I think, for us to have a foundational understanding of how we got to where we are. So natural law theory jurisprudence was, to my mind, the predominant form of jurisprudence for the majority of human civilization in a broad sense, contemporary human civilization. If we think about it, it sort of goes back to Aristotle, and then I'll quickly skip ahead, so I don't need to get into Aristotle and his ethics. But Thomas Aquinas was somebody who sort of Catholicized Aristotle's teachings in natural law theory. And what it essentially did was make these ideas in philosophy available to a broader Western audience at the time. And his interpretation was essentially that God had instilled values in written these in our hearts, and so we could use our heads to divine what moral, righteous laws were that were made to maximize human flourishing. And so you sort of had this Judeo-Christian moralism at the root of what law was. And he felt that it was beholden upon us to use this God-endowed reason to derive moral laws, and that these were in some ways and in many ways superior to what the written laws were of the jurisdiction. So there's an old axiom, and it's unclear whether it was St. Augustine, whether it was Thomas Aquinas, or if this was actually even said by either of them, saying that an unjust law is no law at all. Aquinas, in one of his books, talks about how an unjust law has no binding force. And so that's sort of been misinterpreted. I think it was H.L.A. Hart or Law and Fuller, one of the 20th century jurisprudence kind of gurus, is the one who kind of reintroduced this notion, and I think misattributed the quote. But suffice it to say, you had this idea that at the core of all laws was supposed to be morality, and that this morality was derived from human reason. So fast forward, you then have a guy called Hugo Grotius, who is a Dutch jurist, and he published a book on War and Peace in I think it was 1625. And in it, he had a passage which was somewhat heretical. It's called the Etiamsi Daramus passage. And I don't speak Latin, that's just how I'm pronouncing it, lawyer Latin, in which he said, something to the effect of, even if we were to say that which cannot be said without the utmost wickedness, that there either is no God or that the rules of, or the affairs of man do not concern him, what we are discussing would still have merit. And so this was this idea of cleaving Judeo-Christian moralism from natural law theory jurisprudence and creating the secular morality, basically that you don't need to have a religious underpinning of the idea that human beings can use morality to derive reasonable laws that are meant to maximize human flourishing. You then had later philosophers building on this, like Thomas Hobbes. He was kind of the late 1500s to the mid to late 1600s. And then you had John Locke, who was the early 1600s to like the super early 1700s. You then had this period of the Enlightenment in which we were trying to apply rigor and scientific method and human reason to explore the natural world and move away from sort of superstition and all these other types of things. You still had a really strong religious current going through, but that had begun to erode, and you had this focus on scientific reason. So then fast forward, you now have the late 18th century, you have the American Revolution, which started in 1776, you have the French Revolution in the 1790s, and you have people like Jeremy Bentham, who kind of takes this strong notion of applying scientific method and rigor to this notion of philosophy and jurisprudence to say, what we really need to do is get rid of this idea of moralism in law, because it allows for judges kind of to do whatever they want. He said that as, and I'm going to screw up which philosophers he mentioned, but something to the effect of, as Pythagoras and Euclid were teaching mathematics, Socrates and Xenophon were teaching nonsense upon stilts. So he did not have a very strong belief in the idea of moral philosophy, and basically had this notion that law should be like science, that judges should be applying law in the same way that the laws of nature applied to natural philosophy, which is what the term at that point was for science. So the idea was that you have a legal case, you have the same inputs, you should have the same outputs. So you should completely divorce all moral components and just look at the letter of what the law says. And he gave birth to something called legal positivism. So now that we have this introduction of what the two predominant theories of jurisprudence were, largely natural law theory jurisprudence and then legal positivism, we now have a sweeping suite of changes. You have Watt with the steam engine in the late 18th century. You have a lot of kind of changes moving away from a traditional monarchic hierarchy to more self-governance, starting with the American Revolution. Let's not forget that I mentioned that Grotius published in 1625. That's about 25 years. I think it was 1625. But I think in 1600, Giordano Bruno was burned at the stake for endorsing the heliocentric theory of the universe. You had a lot of censorship going on. There was still a really strong hold in the church that still kind of carries through. You look at the early 17th century in the United States with witch trials and the other things. And we hadn't really necessarily divorce this idea of religious moralism from law. And Bentham did a whole lot to do, kind of separate that. So as we move forward, you then in the mid 19th century have a lot of changes in technology. You have the ability to record things beginning to happen, whether it is a daguerreotype or photography. Later in the 19th century, you have more ability to record things, whether it's wax cylinders or otherwise. And we begin to have this notion that there are some peculiar ideas around how we could potentially have ideas copied in ways that couldn't have been done in the past. We could have images captured in ways they couldn't have been done in the past. And we can have facsimiles of mimetic, facsimiles that approximate mimesis to the point at which some of them to the people at the time were indistinguishable from reality. And so we then have this evolving notion of what actually it means to be private. So in the early 19th century, you have some litigation in the UK around the idea of etchings of particular royal figures that were published in the press and who could control them and whether or not the royal figures had a right to control how the etchings were circulated. So at that time, they relied on copyright law. If you look at a lot of the early notions of what privacy and invasion of privacy was, it related to things like physical trespass. So if you walked onto someone's property to observe them in their home, you weren't violating their privacy because that was a separate right. You were trespassing on their property in order to do a thing. when you look at the American Revolution and you look in the 1790s when the Bill of Rights was adopted. So the United States adopted the Constitution, and then a couple years later adopted the Bill of Rights, which are the first 10 amendments to the Constitution of the United States. I know those Americans or people studying US law will be familiar with this, the international audience might not be. So one of the important things about the Bill of Rights is that there are certain rights in it that people outside the United States may have heard, for instance, in popular cinema or popular culture. So the Fifth Amendment is the right to not be forced to say something in testimony that will can give criminal evidence against yourself. The Fourth Amendment is the right to be secure in our persons, houses, papers, and effects from unreasonable search and seizure unless a warrant is issued and there's specific terms about a warrant. The Second Amendment, of course, is the one for guns. The First Amendment is freedom of speech, freedom of assembly, freedom of religion. And then there's the ever forgotten Third Amendment, which has to do with quartering of troops. The word privacy does not appear in the US Constitution. A lot of people don't realize that. The way that it's framed is the right to be secure in our persons, houses, papers, and effects, which is significant that the word papers is in there, because our persons, houses, and effects certainly would also include papers. But at that time, papers were where we expressed our ideas privately. We used papers to put down our thoughts, keep our diaries, to write letters to one another. And so the idea that papers was specifically enumerated within the Fourth Amendment shows the importance of what the notions of privacy were, even though the word privacy wasn't included. So as we move forward, I want to bring us to 1891. And mystery fans will be familiar with Arthur Conan Doyle, who wrote the Sherlock Holmes cases. There's not the cases, rather, but the stories. And there's one called The Scandal in Bohemia, in which the heir to the crown of Bohemia was about to get married to, I think, a Norwegian princess, but he was concerned that a soprano opera singer called Irene Adler, with whom he had a romantic fling, was going to blackmail him with photographs she had of the two of them and love letters that he had written. Of course, Holmes is hired to try to recover this intimate letter and this photograph from Irene Adler. And so it's sort of wild if we think about in this day and age. I mean, could we imagine a story that would hinge upon the idea of somebody going to recover a photograph and a letter because they were worried that they would be blackmailed and they wanted to get the sole copy of it? In this digital age, we don't worry about the sole copy anymore, because think about how many films would be completely destroyed with the, when I say films, I mean cinema, movies, completely destroyed with the idea of a cell phone and being able to take a picture and put it on the internet immediately. There are dozens of films where there is a literal film canister, celluloid, where some spy took a photograph or some journalist witnessed something, and there's only one copy, and the bad guys are trying to get the one copy, and the good guys are trying to save the copy. I mean, it's the premise of the film Enemy of the State with Will Smith and Gene Hackman. I mean, these are contemporary movie stars. I mean, there are a couple of thrillers in the 1990s that took place in Africa and South America, where a photographer witnessed some kind of atrocity being committed by government, and the whole premise is trying to exfiltrate the photos. Even the film The Rock with Nicolas Cage and Sean Connery had a component, which many people don't recall, about microfilm that a spy had securely stored. Those who remember the end of the film, it's kind of the coda at the end of the movie that Nick Cage goes to recover it. And sorry, spoilers for a film that came out in 1996. But anyway, this idea, though, of things existing in a unique fashion and people trying to have control over them wasn't something that was as concerning then as it is, or was more concerning then than it is today, because of the unique nature of the events that took place. So if this story was published in 1891, think about it, 1890, future US Supreme Court Justice Louis Brandeis and Samuel Warren wrote a very influential law review article in the Harvard Law Review called The Right to Privacy. And in it, he goes through a history of what the notion of privacy is and what the understanding was at this time in 1890. And as I mentioned, a lot of it has to do with copyright. A lot of it had to do with tort. A lot of it had to do with trespass. And we didn't have people running around saying, no, I have a right to privacy. There's a lot of concern over photographs that had been recently taken and used in newspapers and things like that. There was one story he recalls of a woman who, for a Broadway show, was in her stockings, which was somewhat scandalous. And there was a reporter who used a flash bulb to take a picture of her on stage during a performance in her stockings. And this was a scandalous issue that it was published, I think, in a newspaper, and there was a court case about it, and the question of ownership and whether or not this person had a right to do it and how much control this actress, the theater company, had over it. There was a famous 1902 New York case involving the Franklin Mills Flour Company, in which they got an image of a young woman from Rochester, New York, and decided to use this image on a bunch of posters and flyers and on the box for their flour without her permission, and they never compensated her. And in 1902, the New York court ruled that she had no right to the control of her image, and that this could be used commercially without her permission, without her being compensated. Later, one of the judges who issued the opinion, challenged Theodore Roosevelt in a presidential race and lost, and became the very popular subject of the media, and was constantly getting swarmed with what we would later call paparazzi. And at one point, he declared that he should have the right to walk out of his house with his hands in his pockets and not be harassed by people taking his picture. Then, of course, the young woman against whom the court had ruled in this Franklin Mills Flour decision sent him a cheeky letter, which he published in the newspaper, basically saying that he had made his own bed by ruling against her in this privacy and publicity case. Afterwards, the New York State Legislature adopted legislation allowing people to have a right to publicity and a right to use of their own image and that sort of a thing, and several other states followed suit. So that's sort of talking and covering the early notions of what privacy meant from a commercial speech perspective, from a right to publicity perspective, from a right to the use of one's image perspective. And these were new phenomena that people didn't really need to have to think about or legislate before the technology existed that could take advantage of it. So I'm going to kind of change gears for a moment and talk about privacy from government. But before I do that, does anybody have any thoughts or observations or questions about any of the things that I've discussed so far?
I have a question, Mark, and I'm not exactly sure yet how to phrase it, but because when you're talking about privacy and some of the examples you mentioned, you talk a lot about these physical artifacts. So, copies, letters, photos that people can take, physically with them and then do something with for whatever reason. So my question to you is, what is sort of the difference between the privacy of physical artifacts versus the privacy of intangible things? Or any thoughts on that?
So we're going to get there because that's I think the things that we're more interested in with now. But I think it's important for us to recognize, though, that the only reason we're concerned about these more intangible things, to my mind, is because the technology exists to harness or utilize the intangible things. One of the things I teach is international intellectual property law. And I really enjoy the lecture that I give and the discussion with my students on whether or not dance moves should be copyrightable. Because there wasn't a way really to monetize dance moves. But now with a lot of online games and other types of forms of expression, people can not only monetize the idea of doing a dance move. From what I understand, there's a very popular short form video social media platform now, which will have these challenges in which people try to replicate a particular dance, and some of them monetize it. So there's an example of dances being monetized. There's also video games in which people compete and can either unlock through playing or through microtransactions of a few dollars, a few pounds, a few euro, whatever your currency is, get some sort of scripted animation where they press a combination of buttons and then their character does some form of dance that other people within the game world can see. And some of these dances are iconic. I mean, Michael Jackson's Thriller, everybody recognizes that. If I were to say the Carlton dance from The Fresh Prince of Bel-Air, most people would recognize that. So before you could monetize these things, no one really thought too much about the copyright. In the same way that copyright initially in the Statute of Queen Anne was focused on the publishers, not the writers of a piece. So those who organized and put the money in to publish it got the copyright protection. It wasn't until later they amended it so the person who creates the expression gets the copyright on it. Later, you went to and that sort of carried over, where in a lot of different pieces of legislation, international conventions, it isn't the performer who owns the copyright on the piece, but perhaps the person or the company who organized for the recording of the performance. So typically the copyright law tends to favor those who fix it within a particular medium. but I'm digressing a little bit. But that goes to the idea of how law doesn't necessarily create immediately new frameworks to address an issue. It tries to adapt existing framework to confront an issue as it emerges. So that's why I think we're in a very interesting time right now with a lot of digital assets, whether it's digital currency, whether it's in-game content, whether it's data that we create and things by the way that we kind of cruise through the ocean of the internet, surfing the web, as it were. There's all sorts of eddies and currents and things that we alter and imprints that we leave that we don't really recognize that people are now able to collect and monetize, which is now one of the ways that we think about these sort of ideas. So I'm going to quickly shift gears, if that's okay with everybody, to privacy from government, because I think that from maybe the 1920s up until probably the past 3 or 4 years is when privacy from government was something that a lot of people thought about. So I'm going to go back to 1928. I'm going to go back to a US Supreme Court case called Olmstead. I forget if it was US v. Olmstead or Olmstead v. US. The order in which the case caption appears has to do with who filed the appeal to the Supreme Court, which is called a writ of certiorari. So in this case called Olmstead, there were people in Washington state who were running a bootlegging operation. So this was during Prohibition in the United States when alcohol was illegal. And these folks were allegedly, well, not allegedly because they were convicted later, but these folks were organizing a bootlegging operation where they were either making alcohol illegally, but because they were in Washington state, I think they were smuggling it in from Canada. Anyway, they had a base of operations and they were making phone calls. And what ended up happening was the Prohibition authorities put a tap on the phone and were either making recordings or people were transcribing the conversations. And eventually what ended up happening was it went all the way to the US Supreme Court because the lawyers for Olmstead argued that a warrant should have been issued in order to get the taps because the taps were done without a warrant. They said the evidence collected by these phone taps should be excluded. This goes back to this idea of the Fourth Amendment, the right to be secure in our person's houses, papers, and effects if you're in the United States from unreasonable search and seizure unless a specific warrant is issued. So as part of the consequence of this, it was a very bizarre and interesting case because the majority of the Supreme Court of the United States at that time looked at this idea of trespass. You know, we brought this up earlier with the notion of privacy, that you would privacy in your home because in order for people to look in your home, they would need to trespass on your property. So what the Supreme Court and the majority argued at that time was that because no physical trespass occurred on the property, because the tap had been placed on a telephone pole or at a station miles away or kilometers away from where the actual events were recorded, no violation occurred because you don't need a warrant because they didn't trespass onto the property. And this was an opinion written by Chief Justice Taft, the former president, William Howard Taft. I'm not a very good jurist, not a very good Chief Justice. And the only, I don't recall if it was the only dissent, but in the United States system, we have 9 Supreme Court justices, or at least for now, we have 9 Supreme Court justices. In the past, it's changed, but it's been about 9 for about 150 years. And you look to what the majority of the court writes, and if 5 versus 4, the 5 win. If there's different groups, there's 4 and 3 and it mixes up, the plurality kind of holds. And so whichever opinion is the one that wins essentially is binding. Some people think that a 9-0 decision is stronger than a 5-4 decision, but a 5-4 decision is precedential in the same way that a 9-0 decision is precedential. But there's this tradition of dissent where if a justice has strong feelings about the way that a case was put together or the holding of the case or the reasoning of the case, they can issue an opinion which is somewhat different from what the majority or the controlling opinion is. And these are of varying persuasion and sometimes end up becoming better known than the majority opinion. And sometimes the judge will issue a concurrence in which they agree with the outcome, but not with the reasoning. And on occasion, concurrences become what ends up becoming controlling because the court will later adopt that. I can happily answer any questions about the way that the US Supreme Court and US judicial system functions, but I don't want to get bogged down because I could spend hours talking about that. So anyway, in this opinion, Olmstead in 1928, Louis Brandeis, the same co-author of this 1890 article, The Right to Privacy, writes this blistering dissent in which he completely disagrees with the notions there. And I think it is one of the most beautiful legal dissents ever written. And I'd encourage any of you to go read it because it is so prescient. It is so forward-thinking and essentially argues that one of the most cherished rights that people have is the right to be left alone. and that any invasion of privacy needs a significant justification, and that all this evidence should be dismissed, and that a warrant should have been issued, because this is, even though this is ephemeral, it's a telephone conversation, people are expressing their private thoughts, and that they shouldn't be able to be trampled upon, because technology now allows us to do it in a way in a more expedient fashion than we could in the past. Fast forward, you have a 1967 case called Katz, and you have somebody in California who was suspected of running a gambling operation. And this fellow Katz goes into a phone booth and closes the door and makes a telephone call from California to somewhere on the East Coast. I think it was New Jersey. And the federal authorities who are monitoring him decide to be very clever and cute. They know that the Olmstead decision said no physical trespass occurred, therefore it was not a violation of this Fourth Amendment. So rather than putting a recording device inside the phone booth, they put it on top, I think, at the outside of the phone booth. So they could argue, no, we didn't go inside the phone booth. There was no trespass into this kind of private area. And the Supreme Court found this argument unconvincing. A majority opinion in this case in 1967 said that Katz walked into this phone booth, took steps to secure his privacy by closing the door, and shut himself off to the world. So the fact that the tap was on the outside is irrelevant. That the idea was that he took steps to secure his privacy, and therefore there was this understanding that the idea of the Fourth Amendment didn't necessarily protect a physical specific space, but more or less an idea. Justice John Marshall Harlan II, there was a Justice John Harlan in the 1890s. This guy was on the Supreme Court in the 1960s. He wrote a concurrence. And gosh, now I really hope that it was Harlan. And somebody on the call, if you could look up whether this was the Harlan concurrence in Katz or if I'm confusing justices. But whoever it was, I think it was Harlan, wrote a concurrence in Katz, which talked about this notion of the reasonable expectation of privacy. And even though the majority opinion didn't use the phrase reasonable expectation of privacy, the concurrence did. And then that sort of became the normative approach to privacy. And people began to use this expression, a reasonable expectation of privacy based on the things they did or they didn't do. And this is all speaking about from government. So when it comes further down the line, we have a case about 12 years later called Smith versus Maryland. Somebody had been, I forget the exact details, but somebody did some bad stuff and there was a witness. And she was getting phone calls from somebody menacing her all the time. And at one point said, oh, look out your window at a particular time. And she did, and saw a very unique car driving by with a very particular color scheme, and told the authorities, hey, I saw somebody driving a car that looked very unique, and I'll describe it for you. And the person driving it looked like the person who menaced me or that I witnessed doing X, Y, Z, or X, Y, and Z for you UK people. And the authorities in Maryland went to the Department of Motor Vehicles, which has all the registration information for motor vehicles registered in that state. And they put a device on every phone of every person who owned that car in that color, in that model. And the device they put on was called a pen register device, also known as a trap and trace device. What a pen register does is records numbers dialed by a particular phone. So they weren't listening to the phone calls, they were just seeing who everybody who owned this car in this color was dialing. And it turned out that one of the people who owned this car in this color and this make and this model and this year was routinely dialing the phone number of the woman who had reported all this. And they used that as a basis to get a warrant and then arrested this fellow Smith. And that goes all the way to the US Supreme Court. At the time, and still in the United States, under rules from the Federal Communications Commission, companies, telecommunications providers regulated under Title II are required to maintain tolling records for up to 18 months of a particular phone number. People would, at that time, would get phone bills where there'd be a list of every call that they had made and the amount of time the call took place. So the logic the Supreme Court used, based on a 1976 case called United States versus Miller, was that anytime you willingly share information with a third party, you lose all the constitutional expectations of privacy you would normally have under the Fourth Amendment. The idea is that when you use a phone, you get a phone bill, you know the phone company is recording this, you know the person you're calling knows you're calling them. So therefore, it's not a closed circle, it's this open circle because you have three parties involved. and therefore the constitutional expectation of privacy under the Fourth Amendment doesn't apply. You then have a 1986 law called the Stored Communications Act, which includes something called the Electronic Communications Privacy Act. And then going forward, you have further sort of erosions into this notion of privacy from government with what you share to third parties. So the idea being that almost any information you willingly share with a third party, whether it's emailing somebody, because if I use Gmail, for instance, we'll just use Gmail as an example. I use Gmail, then I email somebody at their university address. Gmail, the other person, and I all know that that correspondence took place. There's certain information because of how email works that must be disclosed. I can't email somebody if I don't know their email address. So if I'm emailing somebody, even if the message itself is encrypted and private, the name, my email address, and the person's email address aren't private. So the people with whom I'm corresponding could also be subject to this third-party doctrine. It's also the same with telephones, wireless phones as well. It can be the same with text messages. So people I text, there's third parties involved, because even if we're on the same carrier service, the correspondent and I know the communication took place as well as the communications provider. So it's this kind of very broad notion that we have of what information we're making public to government. There's a few other important Supreme Court cases. There's one called Jones in 2012, where the police really screwed this one up. A nightclub owner in Washington, D.C. was suspected of being involved in drugs. The police had a warrant to put a tracking device on his vehicle. They could do it in a certain amount of time, and they could leave it on for a certain number of days, and they put it on outside the window that they had been permitted, and they left it on for longer than they should have. And they began to argue in court that this fellow's car had been using public streets. It had been perfectly visible the entire time. And consequently, his location did not have a reasonable expectation of privacy. And even though they had put a tracking device on his car, which was kind of a little bit lazy, they could have just had him surveilled and followed by people. And as a consequence, the Supreme Court was very upset with this. I believe, and people might correct me if I'm wrong, I think Justice Scalia wrote the majority opinion. And he went back to this notion of the physical trespass, going back to this notion of trespass from Olmsted in 1928. But eventually they ruled that this was not constitutional. It violated the warrant, and you couldn't just put a GPS tracker on someone's car because it was convenient. Incidentally, there was another case, and I can't remember the year, called Kylo, K-Y-L-L-O. And if anybody wants to look this up and tell me what year it was in the chat, I'll read it out loud. But I believe this was a case that involved police using a thermal imaging device from a public street to point at a house, which they suspected of being a grow house for marijuana. And by pointing the thermal camera at a particular area, they saw that a region of the house was throwing off a lot of heat, and used that as a basis to get a warrant to raid the house, and they found a pot farm. And the question was the warrant deficient because they had based it on this idea of using a thermal imaging camera to look at a house from a public street? So it's, again, law enforcement, and I see that this was 2001. Thank you for looking that up. So this was the idea of the police kind of knowing the kind of the limitations. They didn't go onto the property. They did it from the public street, and they used technology that allows you to look inside of a home. And they argued, oh no, this wasn't special police technology or law enforcement technology. You can get this in stores. You know, that's like, you know, getting a telescope and putting it on top of the Empire State Building and peering into someone's window and saying, oh no, anybody could have done this. So you see law enforcement knowing how to use this and being very particular about it. So why am I telling you all about law enforcement? Oh, and those law students in the space are going to remind me that there's a couple other cases I haven't addressed. There's one called Riley in, I think, 2014, which had to do with doing a search of someone's cell phone without a warrant when they were arrested, and whether or not that was permissible. Turns out it's not. And then there's a recent decision in 2018 called Carpenter in the United States Supreme Court, which looked at historical cell site location data for cell phones and said you needed a warrant to get that wasn't kind of covered in this third-party doctrine. Up until that point, there's a brilliant judge in the Northern District of California called Lucy Coe, who's done some really good stuff on kind of this notion of what the technology components are. The reason I'm talking about all of this when it comes to the notion of privacy is because when we don't have good paradigms in law for how we approach something, we look to existing models and existing frameworks. So when we talk about notions of privacy from from companies, big tech companies, for instance. A lot of people were arguing that under contract law, we are allowing these companies to scan our emails. We're allowing these companies to mine our communications. We're permitting these companies to gather all this information about us, or get together all this information about us because they're providing us with the service. But then the way that that information then gets shared because of other judicial doctrines or other statutory or legal approaches can become problematic. I'm sure that the most people, if they knew that all of their telecommunications metadata, not the content of their calls or text messages, but the information around that could be shared with the US government without their knowledge, people would probably be very concerned. This was something that Edward Snowden revealed in June of 2013 when Glenn Greenwald published a lot of this information in The Guardian. Edward Snowden revealed through Glenn Greenwald that it appeared as though the US government's National Security Agency was collecting all of the metadata around all of the telephone calls used by one of the largest carriers in the United States. And I can tell you from experience that this was the carrier that most congressional offices used on Capitol Hill. So you had an executive branch agency. Granted, this was under President Barack Obama at the time, collecting data on members of Congress and their staff out of their offices. Lawyers used this Verizon, this very popular telecommunications carrier. Judges used Verizon. I'm sure they used other services as well. Independent executive agencies like the Federal Election Commission, the Securities and Exchange Commission used this. And a lot of people, some people, well, it was very controversial news. Some people at the time said, well, I don't mind because they trusted President Barack Obama. A lot of the people who said they didn't mind because they trusted President Barack Obama, expressed concern that President Donald Trump might now have some of these authorities. And the problem is that there's a series of opinions written in the US Supreme Court in the 1940s that had to do with internment of Japanese. A lot of people don't realize this, but the United States on the West Coast during World War II decided to round up and intern in concentration camps, different than the concentration camps in many ways that were in Europe, but they put Japanese Americans and people of Japanese descent in camps on the western coast of the United States. And General DeWitt was the one who was commanded with going through and seeing if this was happening. And an exhaustive review found that there were no instances at all that he could find of people of Japanese descent not being loyal to the United States, which he concluded was proof that treachery was afoot. And that was used as the justification for the internment of the Japanese in the United States during World War II. And there were two significant cases, Korematsu and Hirabayashi. Gordon Hirabayashi and Fred Korematsu were the lead plaintiffs in that. One was a kind of a civil liberties focused guy, and one was just more of a guy. Anyway, they kind of had different approaches and different attitudes toward a lot of the stuff afterwards. One became a speaker, and a civil liberties advocate. One sort of didn't want any publicity at all. But essentially, these were two Japanese guys who had challenged different components of the internment, one the internment and one a curfew. And the Supreme Court at that time essentially said things that are pretty atrocious. It's some of the worst decisions the Supreme Court ever rendered in the 20th century. And they basically just said that distinctions based upon race are odious to a free people, but in times of war, exceptions must be made. And I'm paraphrasing. And basically said, yeah, this is totally okay because we're at war. And then a guy called Robert Jackson, who was a justice on the US Supreme Court, wrote a dissent in which he talked about executive power laying around like a loaded weapon for the next dictator with an urgent need. I'm again paraphrasing and being somewhat hyperbolic. Robert Jackson ended up being the chief prosecutor during the Nuremberg trials later on. So his history is very interesting. He actually didn't graduate from law school. He went for a couple of years, but then was read into the bar. I think he's the last US Supreme Court justice who did not go to law school. But so when you think about the idea of the executive branch or any other branch of government having this power over us with a sense of collecting and monitoring our private data, I think that people need to really be cognizant of the idea that whoever's in power changes every 4 to 8 years. And that I think it's better to have the curtail this ability to drastically surveil us so that we can try to keep more things private than err on the side of giving over this information. So I've wandered a little bit off topic from this notion of privacy, But just to kind of rein things back in, so post-Snowden, a lot of people were very concerned about privacy from government. You saw a lot of legislative pushes, you saw a lot of activism. You saw the sunsetting of Section 215 of the USA Patriot Act, which was the kind of nasty provision that allowed for this massive domestic dragnet surveillance. You saw the passage, that was on May 31st, 2015. On June 2nd, 2015, you saw the passage of the USA Freedom Act, which was aimed to curtail a lot of this mass surveillance. Incidentally, the Foreign Intelligence Surveillance Act of 1976, which created the Foreign Intelligence Surveillance Court, which is the secret court that issues all these orders, was Foreign Intelligence Surveillance Act was not 1976. That was 1978. The Foreign Sovereign Immunities Act was 1976, totally separate thing. But then there was a Foreign Intelligence Surveillance Act, Amendments Act of 2008, which has a section in it called 702, which authorizes the US government to collect information about people outside the United States. And it can incidentally collect information about people in the United States if they're in communication with people outside of the United States who are targets of surveillance. The reason these distinctions are important is because US law doesn't actually prevent the United States from surveilling people outside the United States. The Constitution only protects people who are in the United States. And there's a kind of mixed jurisprudence as to the extent to which the Constitution protects US citizens abroad. Totally a separate issue. But when we go back to this idea of privacy from government, a lot of attitudes and a lot of notions around that look to the idea of encryption, look to the idea of making sure that our data was secure. And then in 2015, you saw, for instance, in July 8th, series of hearings on Capitol Hill about this notion of encryption and going dark, and the idea that law enforcement isn't going to be able to investigate kidnappings and terrorism and drugs and all these horrible things if all of these people who are doing bad things and breaking the law use encryption technology. So you saw people talking about the need for a back door or a side door or a trap door or whatever type of door you wanted, a golden key, a skeleton key that would allow government, when it was lawfully enabled to do so through a warrant or authorization of the owner of the device or the technology or whatever it was, to get inside. Incidentally, there was also a weird thing where some websites went down on July 8th, 2015, and a bunch of flights were grounded because one of the major US airline carriers had some service outage. Very bizarre. We thought the world was ending. Then in December of 2016, you have a shooting in San Bernardino, California, where a fellow named Saeed Farouk, who worked for the Department of Public Health for the county of San Bernardino, ended up orchestrating a mass shooting. I think 20 some odd people were killed and many more were injured. And he was killed at the scene or during the escape. And in his phone, in his car, they found an iPhone 5C, which was owned by the Department of Public Health for the county of San Bernardino. And so the government owned the phone and the government consented to the search of the phone. The problem was it was protected by a passcode, which would auto erase the device or lock it if it was too many failed attempts. And this set off, those of you who may remember, in 2016 rather, in February, Judge Pim in a magistrate court in California had issued an order following a very sophisticated ex parte motion filed by the Department of Justice on behalf of the FBI, basically giving a list of instructions as to how Apple could facilitate them breaking into the device in a sense by removing the security features to allow them to brute force it by going 0000, 0001, 0002 as many times as they could. So they wanted them to remove the auto erase after 10 failed attempts, remove the time delay between successive failed attempts, and allow remote break-in attempts to happen from the cryptanalysis unit at Quantico across the pipe to California. That set off this huge global privacy debate where Apple kind of went nuclear and all this stuff and saying, oh my God, it's this huge policy issue. No one's phone is going to be safe if we do this here. Authoritarian regimes might force us to do this. No one's going to be safe. This undermines global citizen privacy. And it was a really interesting policy argument. The legal issue, though, was the extent to which the US government could compel a third party to do something. Eventually, the case ended up being pulled from court because the government withdrew the request, and it's largely accepted that the Israeli firm Celebrite was the company who facilitated entry into the iPhone. So that's sort of kind of the framework of where we are. That's an understanding of the pressures we have with respect to keeping our data private from government, but we also have these concerns about keeping our data private from companies. And there isn't necessarily a good approach going forward. There isn't a strong legal framework we have to argue that the things we do online are our data, certainly under copyright, for instance. If I were to write an email, I would own the copyright to that email. If I were to post something in an online forum, the terms of use would govern what the license is that's attached to that. This is a big issue with respect to open source software. I know that was one of the keynotes discussed open source software earlier. Just last week, there was an oral argument in the US Supreme Court in a case called Oracle versus Google, which has to do with 37 APIs and libraries in the Java operating kind of environment and its use in the Android operating system. So we're still in this kind of bizarre mix of how we protect our rights, whether it's a combination of copyright, whether it's a notion of trespass, whether there are certain persons' houses, when it comes to our persons' houses, papers, and effects, as to what that actually means with privacy from government. But then there's also concerns about the things that we do online. So if I have a smart home device like an Amazon Echo or a Google Nest or whatever it is, and it begins to create a profile on me, do I own that profile? How can I say that that can be used? Do I have a right to prevent that information from being aggregated into a sense of what we're supposed to be doing on this? And then if I do have some control over those rights, how can I enforce those rights? So if we look at a large social media company and they say, we won't use your data for specific purposes except those outlined here, how do I know that they're using it, that they're only doing it for those purposes? And let's just presume that a large social media company isn't adhering to the terms under which they offered me the service to which I agreed. And I'm able to prove that they haven't. How can I prove harm to recover some kind of damage from them? So I don't know how we are on time. I could go for another 2 or 3 hours, but I guess maybe I should open things up if we want to have any questions or any thoughts. If anybody kind of disagrees with me and wants to hear more about something else, I welcome all comers and I'm eager to hear your thoughts on these things.
You know, in this question of data and companies, especially having the control of the data, I find it's a really important question. And whenever it comes up, I think, wow, okay, these corporations or businesses, they have a lot of power. They can do a lot with this. That being said, they also provide a lot of value, in my life, to society as well, in many ways. So I'm wondering how we can weigh this, when we know that in collecting data from many people, we're able to deliver services that could potentially positively augment the lives of many people around the world, but then can also be this, it's like a double-edged sword.
Absolutely. It's a really difficult question. And I don't want to step on the toes of other panels, because I know COVID-19 is something that has been a lot of issue of focus and something that a lot of people are thinking about and trying to hash through. But if we think about the idea of mobile device-based contact tracing, right, there's a huge amount of information that we could be sharing with third parties that may be government or non-governmental, pseudo-governmental. A lot of jurisdictions don't have good protections as to how that data can be used or misused. A lot of laws tend to have very high standards and requirements to give people the ability to pursue remedies if something has been misused or not properly used. So the idea that something must be done knowingly requires, depending on how it's structured, that the person who commits the act not only does it on purpose, but knows in fact that they're doing it. So rather than a standard of negligence, for instance, because negligence may be something where if I say I can sue somebody for being negligent, if they just didn't exercise due care, I might be able to go after them. But if I say, so if it comes to the idea of COVID-19, let's say that we say anybody who negligently shares non-public COVID-19 health data can be held liable for a financial amount in tort or criminally. That says people pay more attention to what it is they're doing with this data. Whereas if we say, oh, the standard for prosecuting somebody criminally for sharing data when they shouldn't have is willfulness, that implies that they needed to not only know that they were doing it, but share it with the intent to do it. And sometimes maliciousness is even a standard. This is a United States Supreme Court case called New York Times versus Sullivan, where the standard for defamation against a newspaper for a public figure to bring a claim is actual malice. So that if I'm a public figure and a newspaper publishes something in the United States, an American newspaper, and I'm in America, or the United States publishes a story about me that is defamatory, I would need to prove that not only did they know that it was defamatory, that they published it with the purpose of harming my reputation. Defamation law is very different in the UK. And so actually some of the best First Amendment lawyers and free speech lawyers in the world are the lawyers for newspapers, because they have to deal with this kind of stuff more often than that. So when you think about this idea of COVID-19 and privacy, it is a whole new basket of issues that we haven't necessarily confronted. So when it comes to this idea, and I don't really know what the solution is, because certainly, gosh, if I'm involved in a COVID-19 mobile device kind of contact tracing environment, I may want to share my data in an anonymized or pseudonymized or aggregated sense because there's a huge public health purpose. On the other hand, I might not. So there's new things that are emerging that are really interesting. You have data cooperatives or data trusts, where a lot of people are pooling the data about themselves and appointing trustees or people to act as sort of data fiduciaries, which is really, really exciting. There's a lot of solutions that people are trying to put forward now where you are using tools like Tor or Privacy Badger or Ghostery to kind of block these tracking events and cookies. I'd encourage everybody to go to the website, Have I Been Pwned, PWNED, because that looks to see if your email address that you list has been involved in data breaches that have been made public. And there's this whole baskets of laws that we haven't even been able to get to regarding like privacy in education, privacy in healthcare, privacy for children. You mentioned the GDPR earlier, the General Data Protection Regulation. And I know that we're almost out of time. So if I could maybe spend the next minute or so kind of wrapping everything up. And so I began this conversation talking about legal philosophy and what our understanding of rights and how to approach things is and how that was formed. I then talked about how the new technology that we introduced created these environments where new privacy concerns emerged. We weren't necessarily as concerned about somebody seeing an intimate moment in our home if they were the only one seeing it, but they're able to take a picture that kind of changed things. So what the courts often tried to do was hang on existing legal frameworks and infrastructure by looking at things like copyright or trespass in order to get a better understanding of how to wrap our heads around these issues. As the technology shifted, so did the ways that invasion of privacy could be more significant. So not only could we have photographs taken, but videos and audio recordings. We also then began to grow concerned about how governments may collect this information from us or about us, because that could be used not only to maybe shame us, but to put us in jail and restrict our rights and liberties. As we moved in the later part of the 20th century, a lot of legal frameworks began to shift to enable government to be more invasive and more expansive in the information we collect for law enforcement purposes. And then the technologies like social media erupted, which allowed us more easily to share to a wider group of people all these sort of private and intimate things that earlier generations would have never made public. And now we're at this tipping point where we have all this new technology that can affect our rights and affect the things that are public about us in ways that we don't even comprehend and affect the decisions that we make. And it's really unclear what's going to happen going forward. There have been attempts at legislative solutions like the GDPR and some other ones being passed domestically in the United States. But broadly speaking, a lot of these do place the onus on government to proactively go after the bad actors, but leave us very little choice except to look to ways we can proactively protect our privacy and get better control over our data, or rely on existing anachronistic legal structures to protect our rights in courts. So thanks everybody for your participation.
Thank you, Mark, for your enlightening talk. I think, you know, in the whole question of negotiating this new normal, I think you've, at least for me, very much raised the issue of data being a central actually issue, and not just as a little issue. It's actually really quite a profound issue that we definitely need to take with us as we're figuring out what the new normal might be. So I want to thank you, Mark, for joining us here today and for sharing your words with us and your ideas. And yeah, I do hope you continue to be a part of this, and certainly we'll take your ideas with us and create the new normal together. So,
Thanks very much.
so thank you, Mark, and thanks everyone for joining us here today.